Okay, the next case on the calendar is Florida Retail Federation versus the Agency for Healthcare Administration. We've allocated 15 minutes to decide. We'll hear from the appellant.
May it please the Court, this is Brian Newman with Pennington, Moore, Wilkinson, Bell, and Dunbar. On behalf of the Florida Retail Federation, I would ask that if I could reserve 5 minutes for rebuttal.
And remember, you need to keep track of that yourself.
I will, Your Honor. Thank you. The doctrine conferring deference upon an agency's interpretation of a statute is not absolute. The agency's interpretation receives no deference if it is based upon the plain meaning of the term, as ACCA claims their construction of the term usual and customary charges in this case. Further, ACCA's construction of the usual and customary charge is clearly not based upon the expertise of its agency personnel, as indicated clearly by the record below. The Medicaid Pharmacy Bureau Chief, Sybil Richard, testified that the industry definition is that advanced by the Florida Retail Federation in its brief and below with the Division of Administrative Hearings, and that is the price paid by cash-paying customers. It does not factor in prices paid by other private third-party payors. Further, the agency representative designated by ACCA pursuant to Rule 1.310b6 testified, and I'll quote this testimony verbatim, when asked about the rule definition of usual and customary charge, said, "As I said, we don't delve deeply into the usual and customary charge because it would be punitive to the retail pharmacy community, we think, because we think that other insurance plans have dictated substantially lower prices than Medicaid pays. If we average all of those in to come up with a usual and customary charge of what you are charging everybody else because of the proliferation of third-party plans, I think it will be difficult for the pharmacy community to stay in business. I think that that's a very real consideration and something that we have to be aware of and concerned about."
Well, couldn't pharmacies, if that turned out to be the case, couldn't they just stop handling Medicaid situations?
I believe they could, and I believe that.
And then the legislature or ACCA or whoever would start raising the payments for Medicaid to get the pharmacies back in, right?
Well, I believe that by setting the reimbursement methodology that the legislature did, they tried to avoid that and set the reimbursement rate at a rate that would keep the same level of accessibility for the Medicaid recipients that Medicaid recipients have enjoyed.
Isn't that sort of inconsistent with what we all understand to be the efforts both nationally and in Florida to bring Medicaid payments under control?
Yeah, Your Honor, I do believe that has been an effort, but if you lower the prices to the extent that there's no accessibility, then you haven't done the Medicaid recipient any service. And if you look at the methodology, the very exact methodology that was prescribed, including the provision in 409-912, that says that the price reimbursed for Medicaid prescription drugs shall be the average wholesale price minus 13.25% plus a dispensing fee, is an indication that the legislature intended for that to be the major reimbursement that's to apply for Medicaid prescribed drugs. And the testimony below that's uncontroverted is that if the agency actually enforced the usual and customary charge definition that it has in its rule, that it would decrease the availability of Medicaid, of pharmacies to Medicaid recipients who took Medicaid, to fill Medicaid prescribed drugs. And that's part of the legislative intent. You can't just look at the legislative intent adopting this, the reimbursement methodologies to say that we want ACCA, we want you to negotiate the lowest price possible that you can for any Medicaid benefit. You have to balance that with the accessibility of the goods for the Medicaid recipient. The testimony below is that virtually every pharmacy at this point in time is also a Medicaid provider, and that's achieving the goal and the purpose of the statute. The ALJ erred when he rejected Mr. Wells' testimony without any evidence supporting ACCA's construction of the term. There is no evidence supporting the average price paid by third-party payors as a technical definition of the term, and there is no evidence contradicting Professor Creeling's testimony that the Retail Federation's definition is the industry standard. As well, there's no evidence contradicting ACCA's Pharmacy Bureau Chief's agreement with Professor Creeling's industry definition.
Wasn't there evidence that at least 2 other states used the same definition that ACCA is using?
Your Honor, there was no evidence presented below regarding those. There were administrative provisions that have been cited in the answer brief that 2 states out of the numerous states that were surveyed incorporate the prices paid by third-party payors as a component of what it considers to be the usual and customary charge. And those 2 states, I believe, were South Dakota and I believe it was Minnesota. But those 2 definitions differed from the definition that the Agency for Healthcare Administration has even ascribed to the usual and customary charge, and don't provide any support certainly for the definition that they've come up with here. And if you'll look in the answer brief that was filed, they go through a litany of several that have all adopted the technical definition of the term, which I believe is required given the context of the statute. There was no other evidence whatsoever that challenged the definition advanced by Professor Creeling that was contained in the chart book publication that was authored back in November 2001. That was a comprehensive guide and research publication dealing specifically with Medicaid reimbursement. As I said again, and I hate to repeat myself, but the Medicaid Bureau Chief agreed that that was the accepted industry definition of the term. When you have a statute that has to apply a technical definition of the term, that is the definition that should be applied. And we cited in our brief a case from this court, I believe it's a 1983 case, the Insurance Services Office case at 434 Southern 2nd 908, and at footnote 6 specifically rejects the Department of Insurance's attempt to do what ACCA has done here with a term that was an actuarial term. The term was unfairly discriminatory in the insurance context, and the Department of Insurance in that case attempted to apply a definition to that term that wasn't the accepted technical definition of the term. And this court said that you cannot do that. If it's a statute that clearly regulates an industry that has an accepted technical term, that's the term that should be applied, and your construction of that term is accorded no deference. And I would say that that's, in this case, we have something that apparently wasn't present in the insurance services case, and that is we actually have testimony from the agency representative that says that the 2 of them, one says that's not the industry definition of the term, and the other one that admits that we don't apply that definition, we don't apply that rule, and if we did, we would just decrease availability for Medicaid recipients. There's an assertion in the answer brief that ACCA has broad policy-making authority to set Medicaid drugs at whatever price it deems appropriate in order to save the taxpayer money. That simply is not the case given the very direct guidance from the legislature on what the price should be for the reimbursement of Medicaid drugs. The legislature did not confer upon ACCA the authority to negotiate the lowest price possible for Medicaid drugs. That's something that they could have done, but they chose not to. Instead, they set the primary reimbursement, again, at average wholesale price minus 13.25%, a steep discount on the average wholesale list price. That's the cost that comes from the wholesaler to the retail pharmacy, which was adopted consequently following that in the rule as the agency's estimated acquisition cost. I've also cited cases in the brief that discuss the fact that the estimated acquisition cost in the Medicaid reimbursement scheme is intended to be the primary method of reimbursement.
Counsel, if we were to find that the new statute superseded the entire rule. So the rule is out entirely, and we don't have this definition. What is...
Are you referring to the mootness issue, Your Honor, that was...
Well, I'm not only referring to the mootness issue. I'm referring to the problem that arises with the definition of customary usage if there's no rule. I mean, if the whole thing, if the ALJ is wrong to allow this portion of the rule to be severed out and to continue to subsist, what happens to, first of all, your mootness, yes, but then what happens to the definition? I mean,
Your Honor,
where are we?
I'm glad you asked that question, because that's something that I don't believe was adequately explained, and the method of how we got where we got with a rule challenge on a rule that was about to change based on an amendment to the statute. Our clients came to us recognizing that they were not being paid, albeit a little late. They realized they were not being paid at AWP minus 13.25 for the majority of the claims. Instead, they would be paying at wholesale acquisition costs plus 7%. We were considering filing a circuit court action at that point in time versus rule challenge, and the decision was made, although hindsight being 20/20, I wish we had made a different decision at that point, but the decision was made to proceed with the filing of an administrative rule challenge at DOA, because we were concerned that if we filed a circuit court action, they would raise failure to exhaust administrative remedies, and we just have to go back. It was a 30-day quick hearing. We thought that was the best way to get the quickest relief for our clients, and that's the course of action we undertook. Immediately into that process, the agency raised at least twice before we went to the hearing, and we did. We stuck to a 30-day time frame on this case, so it happened very quickly. But they raised the mootness issue twice, and we successfully defended that, arguing that it was not moot because there was still a case in controversy. We were very surprised when the final order came out and found that that our petition was then, he changed his mind and said it was moot as to all but the usual and customary charge. And we don't believe that you can analyze, given the complexity of this issue, the validity of the lower of test in the handbook without looking at all of them together. And that's the reason we assert that, that if it's moot to one, it should have been moot to all.
So you're saying the usual and customary charge can't be severed?
I don't believe that it can.
But where does that leave you?
That's a good question. I think right now we're unsure of where it leaves us at this point.
Can they adopt a non-rule policy until they can adopt another rule defining usual and customary under the new statute?
I'm not sure that the rule is still in effect as to what usual and customary is now. I'm not sure what kind of rulemaking they've gone through since this the final order was entered. Your Honor, I truthfully just don't know that. You know, the statute did not change with regard to usual and customary charges, one of the reimbursement ceilings. But as I mentioned, I believe that's a problem because I don't think you can view this lower up test in isolation.
Well, this would be a retroactive promulgation of a rule to implement a statute that essentially repeals most of the rule, because the rule is not necessary, because the statute takes the place of the rule.
Your Honor, I'm not sure. That's part of the confusion. That's why we felt we had to appeal this ruling before we proceeded to circuit court with a recoupment action.
Okay.
So I see that I may be out of time, and I'm not sure, but I'll reserve the rest unless there are more questions for rebuttal, and thank you.
You've got a little over a minute and a half remaining.
Thank you, Your Honor.
Mr. Chisenhall.
May it please the Court, my name is Garth Chisenhall, and I'm appearing on behalf of the appellee, the State of Florida Agency for Healthcare Administration. As you know, the primary issue in this case is whether or not the ACCA's definition of the term usual and customary charge modifies, enlarges, or contravenes that term, as used in 49.908 and 49.912. As I'll explain, this Court should affirm the final order because the Federation can't demonstrate that ACCA's definition is unreasonable or clearly erroneous.
Would you also address the issue that I asked about the severability of this
Yes, Your Honor.
customary charge from the rule?
I believe the ALJ cited the Ball Harbor case for a proposition that if the entire rule was no longer valid or viable, and he had no jurisdiction to rule on the rule challenge petition, and therefore he concluded that the entire reimbursement rule, except for the definition of usual and customary charge was no longer viable because the legislature amended 409.908 and 409.912 between the time of the hearing. Well, let me back up. They amended statutes, but the statutes, the new ones, came into effect after the hearing, but before ALJ Lanningham issued his final order. And he looked at that and concluded that ACCA could set the prices for drugs by looking exclusively at the new statutes. However, the new statutes still did not set forth a definition of usual and customary charge. So he thought that except for that, that was the only thing that the reimbursement rule was still viable or helpful with. And that is really the sole holding in the final order, that ACCA's definition of usual and customary charge was not unreasonable or clearly erroneous. Now, to begin, most of the Federation's arguments appear to be based on presumption or an assumption that the industry's definition is the only way to define usual and customary charge. However, as discussed in ACCA's answer brief, there's a wide disparity in how the states participating in Medicaid define usual and customary charge. For example, there are some states that have adopted a definition that's consistent with Federation's. However, there are other states like Florida which have either arguably or expressly included the prices paid by third-party payers in their calculations. Also, at least a handful of states have promulgated rules that set forth their own unique and precise definitions of the term. Therefore, the Federation is just wrong when it states or implies that the industry's definition is the only one accepted by participants in Medicaid. Now, in the reply brief, the Federation repeatedly asserts that ACCA is bound by a testimony of its employees and that the agency can't raise any arguments on appeal that contradict or conflict with that testimony. According to the Federation, Jerry Wells and Sybil Richard agreed with the industry's definition. However, if you read their testimony, it's very clear that they were only agreeing that the industry, whichever one that may be, it wasn't really explained very well below, they were only agreeing that the industry defines the term in a way that excludes prices paid by third-party payers. At no time during the hearing below did any of ACCA's witnesses ever agree that the industry's definition was the only way that participants in Medicaid define the term usual and customary charge. In fact, on pages 23 and 24 of his deposition transcript, Mr. Wells was asked about the industry's definition, and he stated, I quote, "I would disagree with that for Medicaid purposes. That's Kaiser's statement, not ours. And as you probably know from reviewing the record on appeal, the Federation's expert witness, along with the Kaiser Foundation, was responsible for producing a book that the Federation cites for its definition of usual and customary charge." Now, in the reply brief, the Federation also argues that ACCA's definition of usual and customary charge is going to lead to a mass exodus of pharmacies from the Medicaid program. First of all, there's no evidence in the record on appeal to support that, so it's really just unfounded speculation. Also, it just doesn't make sense. As you know, under ACCA's definition of usual and customary charge, it includes prices paid by third-party payers and the price paid by someone without health insurance who walks off the street and pays cash or retail for his or her prescription drugs. Therefore, under ACCA's definition, Florida's Medicaid program, when it pays the usual and customary charge, is always going to be paying more for prescription drugs than similarly situated third-party payers. With that being the case, it just doesn't make any sense for one to think that pharmacies are going to leave Florida's Medicaid program in droves. Now, as I mentioned before, the primary issue in this case is whether or not ACCA's definition of usual and customary charge modifies, enlarges, or contravenes that term as it's used in 409.908 and 409.912. With regard to that issue, ACCA's definition is entitled to a considerable degree of deference. As you know, the federal rules governing the Medicaid program had not defined the term usual and customary charge. Also, the Florida legislature has not seen fit to set forth its own definition. And moreover, as I mentioned before, there's a wide disparity in how the states participating in Medicaid have chosen to define the term. Therefore, one could make a very strong argument that how ACA chooses to define a term is really a policy decision. And as this court stated in Crosby, Department of Health and Human Services, policy decisions should not be disturbed by this court. Therefore, if the Federation wishes for Florida to adopt its preferred definition, the Federation should really be presenting these arguments to the legislature right into the court system. But nevertheless, even if this court believes that the primary issue turns on a question of statutory interpretation, ACA's definition is still entitled to a considerable degree of deference. As you know, ACA administers Florida's Medicaid program, and it's well established that when an agency interprets a statute and enforces or administers, that interpretation will not be overturned on appeal unless it is unreasonable or clearly erroneous. And with regard to that question, this court again should affirm the final order because the Federation simply cannot demonstrate that ACA's interpretation is unreasonable or clearly erroneous. First of all, with the prevalence of third-party payers like Blue Cross Blue Shield and Capital Health Plan, there's nothing unreasonable about including the prices charged to them in the calculation of usual and customary charge. Also, because several other states have either arguably or expressly included those prices in their calculations, it just can't be said that ACA's interpretation or definition is not a permissible interpretation or outside the range of reasonable alternatives.
Counsel, so essentially under the rule, ACA is paying a Medicaid recipient an average of what a third-party payer would pay and what a private person without insurance pays. Is that correct?
I believe it's generally correct, Your Honor. Unfortunately, the definition of usual and customary charge was just one aspect of the rule challenge below, and they didn't delve too deeply into the specifics of how the price was calculated. But I believe it does talk about an average, but they don't go into more details about if it's a weighted average or an equal average or anything like that.
But if I may follow up then, so the agency's interpretation of the rule means that a patient, a Medicaid patient who is getting a prescription filled, ACA is going to pay that pharmacist, let's assume worst case scenario, and it is the third party rate, that it's not an average, just for the sake of argument.
Okay.
ACA will pay that pharmacist the exact same amount of money that ACA would pay that pharmacist were a patient to walk in under Blue Cross Blue Shield and have the prescription filled? A third party payer rate?
I think I lost part of your question. Are we still dealing with the usual customary charge?
Yeah, I'm trying to compare what your interpretation of the rule means in the real world, so to speak, regarding payment to the pharmacist. If the pharmacist has a patient walk in who's covered by Blue Cross Blue Shield for drug X, and Blue Cross says to the pharmacist, we pay you $25 for that prescription. A Medicaid recipient for the same drug comes in to get that prescription filled under your agency's interpretation of the rule. Can we assume that the Medicaid program will pay that pharmacist $25?
Well,
At least 20.
At least $25.
Right. Based on what on the nil we know in the record about how that's calculated, I presume that would probably be a nil above 25 because under our definition, we also factor in the price paid by someone who has no health insurance and comes in and pays retail or cash for their prescription drugs. So as Judge Webster said, it would be at least 25, but it would probably be a little more at least. And, you know, by itself, ACA's disagreement with the retail pharmacy industry's definition of usual and customary charge does not render ACA's definition outside the range of reasonable alternatives. Moreover, in addition to being an exceedingly reasonable interpretation, ACA's definition is also more consistent with legislative intent. It's more favorable to Florida's taxpayers, and it's more consistent with common sense. According to the record, ACA is the single largest customer for many of the Federation's retail pharmacy members. Because the legislature intended for ACA to be a cost-effective purchaser of healthcare goods and services, it's very unlikely that the legislature intended for ACA to pay the same price as someone who walks off the street without health insurance and pays retail for prescription drugs. Also, if the legislature disagreed with ACCA's definition, then the legislature could set forth its own definition when amended 409.908 and 409.912 in 2004. Because the legislature chose not to do so, it should be presumed that the legislature agrees or concurs with ACCA's definition. Now, in addition to being more consistent with legislative intent, ACCA's definition is also more favorable to Florida's taxpayers. As you know, Florida's Medicaid program does not have unlimited financial resources. So if ACCA can save some money by not paying retail, then that money can go towards other unmet needs. And finally, common sense supports ACCA's definition. With ACCA being such a large purchaser of prescription drugs, it just doesn't make any sense for ACCA to pay the same price that people without insurance pay who walk off the street and pay retail. In fact, if the agency did so, it would probably be leaving itself open to criticism for mismanaging Florida's Medicaid program.
But, Counsel, I would have to ask you then, though, why did the legislature use a term of art such as usual and customary charge rather than saying ACCA shall pay the third-party reimbursement rate?
Well, I believe that, because the legislature chose not to set forth its own definition a few months ago, it should be presumed. I think it's a canon of statutory interpretation that when the legislature is presumed to be aware of a longstanding interpretation definition, and when they amend the statute without setting forth their own definition, it's presumed that they are agreeing with ACCA's interpretation or definition.
So you didn't think much of the argument in the last case that the 1999 amendments to the Administrative Procedure Act did away with that presumption?
To be honest, Your Honor, I was more focused on my own case at the time. But
Good answer.
But I agree with you on that.
That's a good reason to pay attention to the arguments ahead of yours.
Correct. I'll remember that next week. I think we've already discussed issue 4 in the initial brief about whether or not that was issue 5. In issue 4 in the initial brief, the Federation asserts that the last prong of the reimbursement rule impermissibly combines usual and customary charge with another reimbursement methodology. Quite simply, the argument is not preserved and should be disregarded. Furthermore, even if it were preserved for appellate review, the agency could still interpret the language in 409.908 and 409.912 and perhaps promulgate a new rule setting forth its definition. In conclusion, because the Federation can't demonstrate that ACCA's interpretation or definition is unreasonable or clearly erroneous, the agency respectfully requests that this honorable court affirm the final order. And if there are no other questions from the panel, I'll surrender the rest of my time.
Thank you.
Thank you.
Mr. Newman.
Thank you, Your Honor. Judge Thomas, I'd like to kind of touch on a question that you asked opposing counsel, and I believe you're getting into how this reimbursement scheme really works in practice, and there's testimony to this effect in the deposition that was introduced as an exhibit of Jerry Wells. But there's what's called an instantaneous adjudication of these claims when the Medicaid recipient comes into the pharmacy and gets their prescription filled. The ACS is a subcontractor for the Agency for Healthcare Administration on this, and what they'll do is the amount or the type and the amount of the drug is sent by computer. I'm not a technical person, but they've got an instantaneous feed with ACS, and what's contained on there is what is the drug and the quantity of the drug that has been provided filled for the Medicaid recipient, and the usual and customary charge, which is the pharmacy's retail price, and it doesn't include the average of all with the third-party payors. I don't think there's a retail pharmacy in Florida that can tell you what the average price it pays for every one of these drugs is for every to every third-party payor that it has a contract with. But that is adjudicated there, and it's almost always adjudicated based on what either the AWP minus 13.25% rate is, or the WAC plus 7% rate that we found out they were using as a reimbursement methodology at some point. And you don't know which one they choose. You've just got to, we will pay you X.
So you're saying they don't ever use, this usual and customary thing just doesn't come into play?
Usual and customary charge only comes into play, Your Honor, and there's testimony on this in the record, when the drug is of such a small quantity or such a small cost that the agent, that the amount that they actually bill for it is less than what the dispensing fee would be, which is $4.23 per prescription filled, or less than what the AWP minus 13.25% would be because of some kind of a discount or other factor. And that's in the record as well.
So this is not a major beef?
Your Honor, I'm not sure what impact it will have. I don't know that we know that. I do know that according to Jerry Wells, he believes that the usual and customary definition in the rule would be substantially lower than the AWP minus 13.25%. And that's the only evidence on the record. It's the only competent, substantial evidence. And he says that he believes it will be difficult for pharmacies to stay in business. When I say I don't know, I don't have the figures on that.
And he means assuming ACA starts using that.
If ACA started forcing the retail pharmacy community actually come up with that figure and put it in and bill them for that, then it would be a hardship.
This rule has been in effect for years.
Your Honor, they haven't enforced it, and they just haven't. And that's the only testimony in the record.
Okay.
Thank you.
Thank you.
Thank you both.